What is going on, everybody? Welcome to Friday's Cardone Corner. It is me, Samuel Arms, with Gary Cardone and TJ Roberts, who is going to be joining us to go over the Constitution, which is probably the most fun topic that anyone could ever imagine. Right, TJ?
It is for me. I litigated for a living, so.
Good deal. Well, me and Gary have talked about doing spaces and videos on the Constitution for a while. To Gary's point, I don't think I've ever read the full Constitution from just start to finish. And I'm being completely serious. It's talked about in my education, and my education was supposed to be good, according to some people, but we literally never went over the Constitution. So we put out there looking for people like yourself to kind of go through it with. And a lot of people recommended you, not only because you're a lawyer and you litigate this stuff. I know you're also running for office, but you have experience suing the government, which is why, okay, I think this guy's probably going to understand some of the Constitution if you had to sue the government. Am I right on that?
That is correct. So in 2020, I did something very, very dangerous by going to church on Easter Sunday. And that led to Kentucky Governor Andy Beshear sending Kentucky State Police to track down my license plate number, ordering me to either stay at home for 2 weeks or face up to a year in jail. So I sued him on that ground. First Amendment issue. Thank you. And luckily, we won. The case is called Roberts versus Nice. Throughout that, I was involved with anti-lockdown protests, and I was threatened with arrest on that one. Myself and 3 other organizers, we sued Andy Beshear again over the free speech clause of the First Amendment. We won that one. That's Ramsick versus Beshear. And that's just what I've done as a plaintiff. There's plenty of more cases where we have represented individuals, whether it be Cooperrider versus Beshear, a case that I'm litigating right now, about the governor retaliating against small business owners who refused to shut down in November 2020. Do a whole lot of First Amendment law, currently litigating Second Amendment cases as well. We have Fourth Amendment cases up in the Northern District of Ohio. We have a pretty decent law practice, and it's an honor of a lifetime to be a part of it. And I think it really just comes down to you have to follow the Constitution across the board for everyone, or it matters for no one. Because if you let a constitutional violation slide once, it will slide again and again and again to the point that it won't be worth the paper that it's written on.
Hey, TJ, let me, Sam, if I could interrupt here. Look, I know the audience is going to look at this discussion. The reason I'm holding this is for the last 5 or 6 months, I've been hearing about the Bill of Rights, the Constitution. I'm 66 years old, and I realized, hey, I really don't know any of this stuff. I've reached out to governors, senators, and congressmen, and yeah, we should have a discussion on that. I'm like, yeah, like right now, we should have a discussion. We have 300 million Americans. I'm a rich guy. I have no clue what the Bill of Rights really says or the Constitution. I'm kind of like leading the way going, hey, I'm totally ignorant. And I'm going to bring people into this show that help educate Americans as to what our rights are. I don't think anybody knows. And if you don't know, you're going to let them go away. So that's the purpose of this. It may seem to think that like it's boring, but if we don't have an agreement as to how we live as a country, we have nothing. That is all we're doing, is having constructs and agreements between a large group of people. And if we don't know what those agreements are, we can't possibly follow them. So TJ, why don't we just start, like, let's jump into, I'm going to remove all the faces from this, and let's really just go through the Constitution. I may stop and ask you a bunch of questions if you don't mind.
Sure.
Which TJ, so and you can somewhat take some of the direction on this if you'd like, because I'm very aware that the beginning of the Constitution, and I pulled this up from the United States Senate website, right? I realized the majority of it before the Bill of Rights, correct me if I'm wrong, is really just an organizational document. And I'm happy to read through that. It essentially justifies who has authority and who doesn't. And maybe that's not super exciting. But if we were to go through that, if you have any comments on maybe your experience on how important some of the organizational documentation is, and then obviously with your experience in lawsuits in the First Amendment, we can also briefly touch on that.
Sure. Yeah. I mean, and I'd love to do that because actually, I think that the organizational parts theoretically are more important than the Bill of Rights in terms of protecting liberty. Okay. When you have a separation of powers where power is divided horizontally, but also vertically, which we'll get to once we get to the 10th Amendment, that is actually one of those crucial elements to protecting human liberty, right? And we can go straight into it, of course, with Article One, which is just about the lawmaking of it. The reason why I go straight into Article One is because the preamble, it's just a mission statement, right? It's the part that we all know. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. That's just a mission statement, right?
That
You'll
mission
find,
statement, though, is the reason Lincoln justified the Civil War, though, correct? So even that mission statement's pretty powerful. Am I correct in that?
I mean, Lincoln did that in a rhetorical sense. He never had to go to court to justify it.
Got it.
I can assure, like, so for example, you'll have a whole lot of our friends on the left will say, like, well, it says promote the general welfare. So really that means Congress can do whatever it wants. Well, not really. It doesn't mean that at all. It does, for one, once again, it's the preamble, right? This is telling you why we
But
are putting forth.
isn't that fascinating, though, how immediately off the bat I'm hearing that the way you and other lawyers interpret the preamble as a justification for what should be done, there's already
Yes.
a difference. Like we literally just started, and now I'm hearing that there's a difference in the authority that people in our government and lawyers give the preamble.
Yeah. Well, I haven't heard a single lawyer say that the preamble has legal weight. I've never heard that. I've heard activists say that. But
Got it.
your attorneys, even your attorneys on the left, they're not going to they're not going to go into court and say, well, the preamble tells us we can do this. They're not going
Got
to
it.
do that.
So if we dive into Article 1, here we go. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Which, by the way, I'm also interested. I love how the Senate kind of gives you this little description. I'd be curious if that description is ever as accurate as you think it is. The House of Representatives. Oh, go ahead.
I was about to say that absolutely checks out. That's 100% correct. The legislative power goes to Congress. Congress is bicameral, meaning there's two chambers. One's the House of Representatives, the other's the U.S. Senate. That's 100% correct.
And it's supposed to be significant that the first thing established is Congress. And then the second thing they go into is the House of Representatives, kind of as layers of importance. Am I correct?
It is. I mean, so I think Article 1 came first for a reason, and it's that Congress writes the law, the president executes the law, the courts interpret the law, right? Without Congress, well, there are no laws for the president to actually enforce and for the courts to interpret. So that's one of those. So I think that Congress is clearly the supreme branch. A lot of people use the term co-equal branches. I don't necessarily think that was actually the intent of the founders. I think that Congress, by and large, was meant to be the most powerful branch, because if Congress doesn't authorize this action, the president doesn't get to act on it, and the courts don't get to interpret, right? So without Congress telling the people, like, this is what the law is, there's nothing to be done. There's nothing for the federal government to do. That's actually one thing that's important, by the way. Every law at the federal level is presumed unconstitutional at first. It's a weak presumption, but it's a presumption nonetheless. It is on the government to prove that their law is constitutional at the federal level. Okay, it's the exact opposite at the state level, and we'll get into that later. But for the federal purposes, they have to point to a specific section of the Constitution that justifies what they are doing.
Wow, that's very fascinating. I didn't even know that. So then Section 2, the House of Representatives shall be composed of members chosen every second year. So this is just describing the electoral process. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. So the House of Representatives was intended to be the people's house. Its members were elected directly by the voters in the states. and the entire House would have to stand for election every 2 years. So right there, you kind of see some federalism, correct? Which is where the states obviously already have a say in what's going on.
Yes. Yep. Right. I mean, and that's the thing is like in many ways, well, for one, who are the people who actually ratified the Constitution? It was the delegates of the states, right? We could look at that in Article 7 of the United States Constitution. It was the states that created the federal government. So, needless to say, in order to get that ratification through, after these states just came out from being under a massive government, a whole lot of concessions had to be made. Right? We had the very weak federal government under the Articles of Confederation from 1777 until the ratification of the United States Constitution. It took a whole lot of balancing acts to get the states to agree. And there were serious fights in various states about whether or not they were going to ratify the Constitution at all, even with the safeguards that were put in.
Which I think sometimes people forget, because I even forget, that the Constitution came how many years later after 1776? Was it about 20 or 30?
It was 11 years. It was ratified in 1787.
1787. Okay, and so between then you had the Articles of Confederation.
Yes.
So then this part just seems to be what is famous for determining the age limits of running for office, correct?
Yep. I'm old enough to be in Congress. I'm not old enough to be in the Senate.
Interesting how they just decide that, because all the guys who, fought, a lot of the guys who fought in 1776, I thought were below the age of 30, so I find that kind of interesting that they compared it to 30.
Yeah.
So what is this part? Representatives and direct taxes shall be apportioned among the several states which may be included within this union. Okay, so this is just saying membership in the House is apportioned according to the population of states. And this is why our census is important.
Yes. Yep.
Every state
Also,
must have at least one House seat. Yeah, go ahead.
And by the way, that is actually a crucial issue right now. I live in Kentucky. We have 6 congressmen. We have both our Congress and our Electoral College based on population from our Census Bureau. Well, our Census Bureau currently counts illegal immigrants. California alone has enough illegal immigrants to where they have more members of Congress just representing illegal immigrants than Kentucky has whatsoever. Same thing with our Electoral College as well. So in many ways, how the Census Bureau counts population, that's a slept-on issue that a lot of Americans need to wake up to, because if you live in a state like mine that has only like 4.5 million people, California by itself has disenfranchised you at the federal level by having so many people who legally are not supposed to be here, but they've gotten more members of Congress, they've gotten more electors as a result.
Now, didn't the Trump administration file a lawsuit to make it so that the Electoral College was only apportioned by United States citizens as opposed to total population?
I know that there was an effort to do that. I don't know what the end result of that was, but I know as of right now, of the Electoral College, they count every human being.
Isn't that interesting? So I think a lot of people always assume, oh, more people are coming here, they're trying to register them to vote. But you don't necessarily need to register everybody here to vote, because like you're saying, you just get more power from having more total population in your district, which creates these perverse incentives for maybe California to say, hey guys, come in through California so that by the next census, we have more sway over Congress and the electoral process.
Correct. And by the way, this issue that I'm talking about here, funny enough, when you're looking at this document here, there's parts in this that was meant to prevent disproportionate representation for those who don't vote, who don't take part in the electoral process. So when you look at the population, it states the number of free persons, including those bound to serve a term of years, that's indentured servants, and excluding Indians not taxed. So Indians who are living in sovereign lands that you don't have the elections in, those don't count, then 3/5 of all other persons. So, real interesting fact about the 3/5 compromise. It was actually an anti-slavery measure. It was the southern states that wanted slaves to be counted in the census. The question of why would they want that? Well, it would have given the South more members of Congress. It would have made it harder for northern states, anti-slave states, to amend the Constitution to get rid of slavery. It was actually the northern states. John Adams made a retort about counting slaves in the census of, well, what's next? Are we gonna count the farm animals too? Which that wasn't John Adams' his way of saying that slaves aren't people. That was his way of saying you're not treating them like people. You're not letting them vote. Why should they count? Well, the 3/5 compromise was just that. It was a compromise to make sure that that issue didn't completely blow up the founding of the country.
I think a lot of people forget that. Isn't that interesting how the narrative on that is completely backwards?
Yeah, because you'll hear people on the left say like, "Oh well, we were only 3/5 of the people. They like black people were only 3/5 of a person at the time." No, that's not what the law said. It said they counted as 3/5 if they were slaves, and the reason why was because, well, slaves couldn't vote. They weren't treated like people in the southern states. That's wrong. They should have been. Slavery should have never existed. There was a first draft of the Declaration of Independence that condemned slavery, but in the interest of taking on the big fight of the British, well, they chose to just stop on that end. But that's the thing is like that 3/5 compromise actually sped up the abolition of slavery because it made it to where there was more disproportionate to where the North was actually the dominant force in Congress, which is what was needed to ratify the 13th Amendment.
Is that excluding Indians who are not taxed? Would that be the reason people argue that the census should be taken from citizens only? Because it would say you're only counted if you're taxed.
It's part of it. It's just showing, but the other argument though is it says by adding to the whole number of free persons, right? Doesn't say if those free persons have to be taxed or not. Now you could say there's a presumption that they are. See, I mean, like this is one of those things that gets really complex, and here we are just looking at a tiny clause in Article 1, Section 1 of the Constitution talking about the House of Representatives here, and we are already spending so much time just parsing out these. We're looking at just individuals like segments of a sentence in it because of that, right? It's a complex argument on it, but that's part of it is just showing like, hey, we have these exceptions here, so why shouldn't we do that?
Do you have any comments? I know maybe this is taking longer because some of my questions.
No, I just keep going through it.
For many years, the House increased its size as the nation's population grew, but in 1911, the number of representatives was fixed at 435, together with non-voting delegates representing several territories in the District of Columbia. Words in italics indicate provisions that were later dropped from the Constitution. The 13th Amendment abolished slavery, and the 14th Amendment provided that representation would be determined according to the whole number of persons in each state, not by the 3/5 of the slaves. Since American Indians are now taxed, they are counted for purposes of appointment. And until such enumeration shall be made, the state of New Hampshire shall be entitled to choose Massachusetts 8. Oh, okay. So
Sam,
yeah, go ahead.
Sam, while you're reading through that, TJ, when does this document no longer represent the world we live in?
I mean, I would actually say that the Constitution never represented the world. It's only represented America. America's been
the world we live in, not the whole world, but the world that we live in, like this Indian thing. Hey, it's antiquated. Okay. They pay taxes now. Let's move on. I'm just sitting here looking at this going, we're in 3 pages, 7 pages, and we're already getting stuck on meanings.
Yeah. So
Wouldn't it be just easier to rewrite this bloody thing right now relative to the 21st century?
there is I mean, the Constitution does outline a process to change it, and that's in Article 5. The last time we did it was in 1992 with the ratification of the 27th Amendment. A little bit of interesting
Which
history.
means what? What's the 27th?
The 27th Amendment makes it to where Congress cannot adjust their pay without an intervening election. So they can't give themselves a pay increase, or they can't cut the pay of various members without an intervening election. I actually did a lawsuit. I was involved in a Supreme Court case involving that amendment. We were representing Thomas Massey, Marjorie Taylor Greene, and Ralph Norman against Nancy Pelosi after she tried to cut their pay for refusing to wear a mask. And we said this violates the 27th Amendment. Unfortunately, the DC Circuit sided with Pelosi on the grounds of legislative speech or debate immunity. I don't think that's what it was meant to say, but unfortunately, the Supreme Court did not grant cert. I was involved in the Supreme Court practice of it. It was a fascinating one, but interesting piece of history on the 27th Amendment. It was originally introduced with the Bill of Rights in 1791. It just lay dormant for 200 years. And then eventually, this college student in Texas wrote a paper about how that amendment's not dead, it's just dormant. Congress could ratify it right now. The states could ratify it right now. The professor gave him like a C- or something.
What does dormant mean?
Asleep.
Like no one was using it, or it's not official?
Yeah, it's not official, wasn't passed, it's pending. So on the set on it though, this kid, he got like a C- on his paper. It was like his final paper in college. He asked the professor, if I get this amendment ratified into law, will you upgrade my grade to an A? The professor took him up on it, thinking he's not going to actually do this. He started an entire lobby to get a constitutional amendment through just to prove his professor wrong, and he did it. So that's how this became the law. There's the story right there. In 1982, Gregory Watson, sophomore at Yep, that's why he did it, was because he got a bad grade on a paper.
That sounds like some pretty amazing motivation. Okay, so if we go back to it, okay, so vacancies. When vacancies happen in the representation from any state, the executive authority thereof shall issue rights of election to fill such vacancies.
And by the way,
House seats. Yeah, go ahead.
So interestingly enough, that has been amended, at least for the U.S. Senate, with the 17th Amendment.
Because we used to not be able to elect our senators; they were appointed by the House, the state. Correct.
Correct. But yeah, I'm talking about specifically about the vacancies. Like for the U.S. Senate, that was amended with the 17th Amendment.
Interesting. In the 17th Amendment is what? Let me look.
It's the direct election of U.S. senators.
Gotcha. And before that, they were appointed by the state?
Yes.
The House of Representatives. The House of Representatives shall choose their speaker and other offices and shall have the sole power of impeachment. So representatives choose their presiding officer, the speaker, from among the membership of the majority party. That's interesting. So when they wrote this, they already knew that there were going to be parties. Other elected officers, such as the chaplain, clerk of the House, sergeant at arms, and doorkeeper, are not members of the House. Impeachment is the power to remove federal officers. The House initiates the process by voting to impeach, which then refers the matter to the Senate for trial.
So one thing, that commentary, when it's talking about from the majority party, that's an additive. So parties are not mentioned in the Constitution. They existed at the time, though, so they knew that was coming. But the fact that the speaker was chosen by the majority party, that's not constitutionally mandated. It could be the entire floor. There could theoretically be a time where you have a unanimous Speaker of the House. And, for example, the Speaker of the House doesn't even have to be a member of Congress.
That's right, because I remember people saying that Trump could be the next Speaker of the House during when they were looking before Mike Johnson became our current Speaker.
as a matter of constitutional law, that there would be nothing prohibiting that, and I'm pretty sure a lawsuit to stop that would be barred as a non-delegable political question. Of this was solely given to the House to decide, and it's on the House to decide. It's not on the court to decide what that means.
Got it. Understood. So how do we look at this at a high level?
So the higher level of it is the founders were very careful in how they formed Congress, how they formed the presidency, how they formed the courts. They were focused on making sure that there was a balance to where if every American is going to be bound, they need to be bound to what is a total national consensus. We did not create a government that's meant to move quickly. It's meant to be gradual. It's meant to be slow. Your actual fast moving stuff is more supposed to be at your state level, at your families, your churches, your communities, right? And that's one thing. We have the House of Representatives elected by the people. You have the United States Senate, which was originally chosen by the state legislatures. I actually, on my end, I think that the ratification of the 17th Amendment was a mistake, if I'm being completely honest. The House of Representatives was supposed to represent the people. The U.S. Senate was supposed to represent the state's interests, right? This was meant to prevent the federal government from superimposing itself on state governments. When the progressives, and by the way, it was the progressives who pushed the ratification of the 17th Amendment, when they ratified that, they made it to where now the Senate just represents all of the people without regard for the interests of their state government, right? So now you had two chambers, which theoretically, yeah, you could play procedural games to stop things, but the substantive difference went away when we ratified this. Which, by the way, the same people who pushed the 17th Amendment were the same people who pushed the 16th Amendment, which authorizes the income tax. Another amendment that I think was a mistake.
Interesting. So your specialization is in the First Amendment, and that's how you've sued and won a lot of your court cases, or that's kind of what your expertise has been?
So in terms of litigation, the First, Second, and Fourth Amendments are the big ones that I focus on. I was a teaching assistant, though, for Article 1, 2, 3, 4. Yeah, 1, 2, 3, and 4. So those are the ones that I actually helped teach law students about. So, and the First Amendment and the 14th Amendment. We do a whole lot of 14th Amendment cases, by the way, because we mostly sue state governments, and up until the ratification of the 14th Amendment, the Bill of Rights did not apply to the states. States were more than welcome to violate the Bill of Rights. So the 14th Amendment is actually what incorporates it. You'll notice in every complaint that I file against the state government, I indicate that it's a violation of the First and 14th Amendment, violation of the Second and 14th Amendment, violation of the Fourth and 14th, Fifth and 14th, so on and so forth. If you're suing a state government for a violation of the Bill of Rights and you're not citing to the 14th Amendment and 42 U.S. Code 1983, you're probably malpracticing. Probably.
I didn't realize that the states you said the states didn't sign on to the original Bill of Rights or weren't bound by it originally?
They were not bound by it at all. It was only meant to, and you'll notice the first word of Amendment 1, Congress, right? It doesn't say no government shall make any law respecting an establishment. It says Congress shall make no law. And there's actually a Supreme Court case from before we ratified the 14th Amendment called Barron versus Baltimore that made clear the Bill of Rights does not restrain state governments. The 14th Amendment is what made it to where they do. And by the way, there's still two constitutional amendments that hasn't been incorporated to the states. The Third Amendment, which prohibits the forced quartering of troops. The Second Circuit, which covers New York, I believe, did incorporate the Third Amendment to the states, but the Supreme Court hasn't taken up the case. And then the other one is the Seventh Amendment right to a jury for civil cases. So those two amendments still do not restrain states, mostly.
So when we look at the First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peacefully to assemble and to petition the government for a redress of grievances. And they say here the first 10 amendments comprise the Bill of Rights. The First Amendment protects religious freedom by prohibiting the establishment of an official or exclusive church or sect. Free speech and free press are protected, although they can be limited for reasons of defamation, obscenity, and certain forms of state censorship, especially during wartime. I wonder if that was added on later. I guess it would be. The freedom of assembly and petition also covers marching, picketing, and pamphleteering. So the First Amendment's interesting, right? Because that's what makes, I hear all the time, America uniquely America, right? So, I mean, you want to dive into some of this? Because I assume this is behind tons of lawsuits, right?
Absolutely. I mean, yes. So I will say, I'm not sure what they mean by saying, especially during wartime, because I don't think there's a wartime exception to the First Amendment. And in fact, we can see that wartime does not lead to the Constitution going away. And that's especially whenever you look at Ex parte Milligan. That's a Supreme Court case about holding civilians in tribunals. We had a bunch of Civil War cases like Ex parte Merryman, talking about the applicability of the Constitution during emergencies. It was a narrow decision, but they held the Constitution applies during war. So I dispute that part of it. Everything else here seems pretty much accurate. I wish that they would tell you more about what it means, because obscenity isn't like someone cussing, and that means that the First Amendment doesn't protect that. Obscenity actually is a legal term, and the definition that we use now is we use the Miller test, which holds that you can have the government regulating content if it, one, appeals to the prurient interest, sexual by its nature. It is by its nature patently offensive in a sexually explicit manner, and the work taken as a whole offers no serious redeeming social, political, artistic, or scientific value. Okay, and you have to meet all three of those in order for it to be obscenity. There are more exceptions as well. Like, for example, we have New York versus Ferber, which explicitly holds child porn is not protected no matter what, even if it had redeeming, like, social, political, scientific, literary value. It's far beyond that, because the interest of protecting children is far more important than whatever art they're trying to hawk off by exploiting children, right? That defamation, false statements against a private figure that causes damage to their reputation, yeah, they can recover. But I'm a politician, okay? The standard is different for me. If I want to sue for defamation, I have to prove actual malice, which doesn't mean that I have to prove that these guys don't like me. Rather, what I have to prove is that when they made the factual statement about me, that not only was it false then, but they knew it was false when they said it, or at least had reckless disregard for whether it was true or not. I can assure you there were plenty of things that came out in my primary campaign that I wanted to sue over. But good luck proving to the court that someone knew something at the time that they said, that they made the falsehood, right? You basically are forced to engage in mind reading. But overarchingly, yeah, speech is protected. And on the wartime one of my personal favorite cases, there is one wartime case where theoretically you do have some exceptions. I don't remember the specific case name, but it was a case against Progressive Magazine. They were going to publish during the Cold War a step-by-step instruction guide on how to build a hydrogen bomb. The government shut them down for doing so. They sued, and a district court held it was constitutional for prior restraint on that. That never got appealed up to the Supreme Court, so we don't know how that would have gone. That being said, probably okay to say, yeah, you can't teach people how to build a nuclear bomb. Probably, but press freedom, huge issues as well. Unfortunately,
What about
now we
code?
have.
You always hear, "Oh, code is free speech." Have you ever heard that before?
Yes,
When they're
I
talking
have,
about things like Bitcoin.
yes, and in fact, that's an issue that I care deeply about as well, from a Second Amendment perspective, because as far as I'm concerned, the gun control debate is over. It's done. There's no argument to be had now. Even if you regulate guns out of existence in terms of like gun shops and transfers of them, 3D printers exist, and 3D printers can create very hard plastics, and they can also etch into pieces of aluminum and steel. It's done. So even if they somehow repeal the Second Amendment, the First Amendment will protect access to firearms forever. It's done
Because of code?
because of code. You can code, and that's actually Defense Distributed litigated this like crazy about their Ghost Gunner machine, and that was the big thing, the big crux of.
Are you familiar with that, Gary?
Yeah.
So, and never mind the history and tradition of Americans regularly building their own firearms, right? So it's an interesting thing. The Second Amendment facially protects firearms, but I would say that the First Amendment, in many ways, up until Bruin, did more to protect firearms than the Second Amendment did. The Second Amendment, you only have 4 Supreme Court cases, actually 5 now. So the first one was District of Columbia versus Heller. Okay, that one held that the Second Amendment does protect an individual right. You have McDonald versus City of Chicago. That's the case that held that the Second Amendment does apply to the states. Remember how I was saying it does? The second, like the Bill of Rights, only restrained the federal government at first. Well, McDonald versus City of Chicago says state governments have to follow it too. Then you get Caetano versus Massachusetts, which just reaffirms that the Second Amendment protects access to modern weaponry. It struck down the stun gun ban in Massachusetts. Then you get Bruin, which holds that it applies outside the home and that the standard of analysis is not a balancing act, but it's the plain text of the Second Amendment plus the history and tradition. So the history and tradition looks to what was acceptable when the Second Amendment was first ratified. What could we regulate? And now we have Rahimi, which is actually where they upheld a gun regulation against an individual who had a due process clause satisfying domestic violence restraining order imposed against him. He had the ability to contest it. He chose not to. And then he committed further acts of violence. They arrested him for possession of a firearm after he committed 5 subsequent shootings after the DVRO was imposed. And the Supreme Court held, yeah, it's constitutional to disarm this guy temporarily, not permanently, temporarily. If you've had the chance to defend yourself in court, first and foremost.
It's wild to me that you can just throw out these Supreme Court cases, and I like some of it goes over my head because I'm like, okay, I didn't know any of that was happening, and I also didn't know half these. Like, I don't know the name of any of these cases, and I also don't know like how they minutely are affecting your ability to, say, for existing example, own a gun, right? So it's no wonder to me that people get confused with the Constitution, because I have a simple plan of, hey, we can just read through this thing and understand it. But what I'm really hearing is, hey, Sam, you can read through it and understand it, but we have 200 years of court cases that are actually putting parentheses and definitions and redefinitions, almost making it impossible for the modern American. Like, if I was taught this in high school, would that even matter when it could have, when like even what we're talking about now, that court case could have been 5 years ago. So then boom, what I'm reading in the Constitution is already different.
That's a fair criticism. The one piece of good news is the Supreme Court is, by and large, heading in a textualist direction. So
What does that mean?
So the plain text is what ultimately matters, right? Not what did you mean to say, but what did you say? Okay,
What are the words? What are the actual words?
correct. What are the actual words? What did those words mean when it was written? Those are that's more or less what textualism means. Um, the offshoot of textualism that is largely used in constitutional cases is known as originalism, which is what did those words mean when it was written, and that's where you use history and tradition to determine that. Like, for example, freedom of speech. Well, what exactly is speech? Right? The founding fathers would have never envisioned that like a cell phone text message is speech, but you take the principle, right, that it protected communications, conversations, political speech, and realize that this is just a modern way of conveying those ideas. You come to the conclusion that 1791 principle of free speech does apply to the 2024 cell phone, right? That's more or less what I mean by originalism, by textualism.
So originalism kind of helps with technological progression because it's
It
just this
does.
broad idea. Whereas, because I do hear people say, well, do we need to update the Constitution for modern times? But then the question is, well, do you need to if you're looking at the principles? And if you do update it, are they going to make carve outs? Like to your example, oh, they were just talking about spoken word. Your texts do not count as free speech if we were to redefine that.
Right. And that's the issue, right? You could also take it with the Fourth Amendment, which protects you from unreasonable searches and seizures of your person, houses, papers, or effects. One of my favorite interactions I got to see in person, actually. Judge Andrew Napolitano, who I did a summer mentorship with, he was speaking.
Who is that? That's a
He's
famous name, isn't it?
Yeah, he's a former Fox News legal analyst. He does his own show, just one of the most brilliant legal minds who's still offering commentary. He did a speech with former Supreme Court Justice Antonin Scalia. And during the conversation, they're talking about the Fourth Amendment. And Napolitano just pulls out someone and was like, well, Justice Scalia, is this in effect for purposes of the Fourth Amendment? And Scalia's answer was the perfect judge answer. Just, I don't know. We might have a case come up on it, though. Sure enough, it did. Carpenter versus United States. And now, actually, the data on your cell phone and the contents of your cell phone is protected under the Fourth Amendment. Now, the reasoning is where the justices disagree. I take the Neil Gorsuch approach to it. I believe that your cell phone is your property, and therefore the data on it is also your property.
Fourth Amendment, by the way, guys, is search and seizure. Most guys won't know this, guys. So just remind everybody what these are.
Okay, absolutely. So John Roberts had a very interesting take on it, though. He said that a cell phone, your computer, your laptop, these are so integral in your modern way of life that they are essentially a part of your person, not an effect. I don't necessarily agree with that logic, but it came to the right conclusion either way. So, but one in my opinion, one of the most bastardized amendments is the Fourth Amendment, unfortunately, and a whole lot of that was because we just had such a fury to address the drug war that we forgot about the protections of Americans about your right not to be searched without probable cause or a warrant. We just totally forgot about that. And if you guys ever want to read a really, really good opinion on it, check out Neil Gorsuch's opinion in Carpenter versus United States. The way that he starts it off is he says, what is left of the Fourth Amendment? And it's a good question because there's not much left, unfortunately.
Hey, TJ, let me ask you a question, man, on this. And sorry to break your stride if you were in the middle of something.
No, absolutely.
When does the phone, when does Google, Amazon, all these platforms now look more like utilities? Can't live without them. Here's a good example. I'm getting ready to file that 85% of my house that I live in is going to be paid by the U.S. government through taxation. Now, my reasoning is in 2019, I was told I could not go to my office, 27,000 square feet, 5-year lease or 10-year lease. I'm locked out of my office. My staff can't go. My children, who are legally required to go to school, and I will go to jail if I don't send them, no longer was available. So I had to build a schoolroom in my home. Like everything I've done now in the last 4 years is to protect my businesses and my families because of what the response from the U.S. government and other governments were to prevent me from accessing utilities. When does it become, and I think I'll win this argument, and I think many Americans are going to do the same exact thing, file taxes on, hey, look, 80% of my house is my business now. I entertain, I do everything here. My question to you is, when is it that Google or a phone app or something becomes a utility and that firm can no longer behave the way they were behaving before commercially, which is, hey, let's just extort and charge as much as we possibly can because we're Google and we're going to take 30. This is a good example. We're Google. If somebody sends you $300 right now, they're going to take $100 from you just for sitting on their platform. And you're the guy with all the content. So I'm really confused here. You're the author. You've worked 30 years of your life. You're analyzing all this data. And if I send you $300, Google, which is effectively a highway, and there's only 3 or 4 of them, will take 33% of that is a tariff. Now, when does that become just outright illegal, wrong in every angle, and that we have a right to go after these companies as highways?
So there was just a federal court decision either this week or last week that held that Google is a monopoly under the Sherman Act. That was actually landmark. I don't know what's going to happen to it on appeal. Antitrust law is not in my wheelhouse all too much. I know enough to be dangerous. I don't know enough to actually litigate the case. And by being dangerous, I mean I know enough to mess it up really badly. So I don't want to go on the record firmly on that area. What one part of being a lawyer is also knowing when you don't know what you're talking about. That said, when we're talking about that in terms of the monopoly area, the Sherman Act is more of a common law area where the judges make these decisions. And we're actually seeing a whole lot of more judges on both sides of the aisle, luckily, being more cautious whenever they see the warning signs of monopolistic activity, which I think that is a good thing. Look, I'm very skeptical about government involvement in private businesses. Generally speaking, if you create a product or a service that is so good that no one competes with you, who is the government to get in the way of you doing that? But these monopolies, let's face it, that's not how they get their monopolies. They get their monopolies through government subsidy, through statutes, through regulation, their competition, right? So I feel like it's a necessary evil to have right now, like what you're talking about, to make it to where there's some sort of limitation. Now, there is actually an interesting area as well. This is an extremely narrow part of constitutional law about when private entities can operate under color of law. That matters because the Bill of Rights doesn't apply to private entities. Private businesses can say, no guns. You can't break into my house and cuss me out and then present a First Amendment defense, right? But in very narrow cases, there are times where private entities act so authoritatively and control so much area that they themselves are effectively a government. The big example, there was a Supreme Court case about private towns that made it to where the First Amendment applied to them. So it's extremely narrow, and it's a very high bar to get to. But that's the closest to an answer to your question I can really get to.
Thank you. Thank you. I mean, it sounds like you think that's going to start becoming an issue, right? People are going to, I mean, if ExxonMobil was making a 130% margin and $20 billion a quarter in profit, there would be riots in the street, right?
Yes.
If you had a policeman that was stopping you on the way to school every day going, hey, I need $20 just to get through that road, it would be that is what's happening. And this is what I was asking about. Hey, when does the Constitution become something that's no longer even valid? Because the world has changed so much. Never, ever. Like I see 1930 SEC documentations and legal views on a number of different security and commodity issues that are so dated. Like it's literally just going to make us old, non-innovative, slow reacting country that's not able to get in front of this new world that we're moving into, which is going to look very different than the old world, man. Right? Like can I have free speech in the UK and then fly to the UK and then somebody looks at me and says, hey, we don't like what you did on Facebook and we're going to either not let you in this country or we're going to put you in a jail room for a few days because I broke their speech, what they consider to be fair and valid. I mean, the world is just like, you don't really know what to do, right? Either as an individual, like I don't really know how to protect my rights when somebody just grabs $100 from me out of 300. That feels very mafia, right? If Visa, MasterCard were doing that, I can't operate without Google, YouTube, a few of these systems. I mean, look, I changed my picture the other day. There'd be 3,000 people in this room. One minor little change really messes everything up, right? So I wonder if any of our rules, laws, bills actually are they slowing us down?
I mean, I would say that a whole lot of our laws slow us down. Now, I think that the Constitution, however, was designed to stop the laws from slowing us down and hindering the human experience. I would say, especially when you're talking about these areas, I would say that it's overburdensome federal statute, not the Constitution, that's actually causing the pains of society. I would say that if we actually followed the Constitution, we wouldn't have federal federal spending programs designed to create monopolies that suppress the individual experience, right? We would have a sense of federalism where you would be able to vote by your feet, where California's regulations, for example, would only be for California, but California has regulated in such a broad fashion that, like, for example, in auto industry, cars that I purchase in Kentucky, they follow the California regulations, even though Kentucky would do nothing to them for not doing it, right? I would actually say that, frankly, a strict adherence to the Constitution would actually solve your problems more so than just updating the Constitution. Because one of the things that terrifies me anytime there's talks about amending the Constitution is I don't trust the government. I just don't. And I don't trust them to appoint delegates who would actually have our interests at heart if we were trying to amend the Constitution. I would trust them to have the oppressor's interests at heart, because let's face it, I mean, who's going to be picking the delegates? It ain't going to be us, right? If we could control it and truly do it, yeah, I'd be game to get some amendments in there.
I
wasn't
suggesting that we could amend it.
Sure.
Like, I wasn't saying that. I'm literally saying, hey, when does it actually become a problem for us? Like, I just think the United States and most other countries are moving into great civil unrest, and polarization. This agreement is going to be challenged, and it is being challenged. And at some point, it will be ripped apart, or it will be valid for re-signed, re-agreed upon, because nobody's in agreement with this. Nobody fucking understands it. And you can argue about it in court forever and ever and ever. That's a problem.
It's an issue. That said, I do just I'm firm on the notion that I think more constitutionalism is the answer. Because right now we just have a lawless federal government. Um, and and that's the thing is like if we were actually adhering to our founding documents, that's where I think that we could actually come together as a country. Now, the rest of the world might be upset with us, but hey, we're America. We're separated by two oceans from the rest of the world, so they can deal with it.
I think we underestimated the complexity of doing this. Like, how would you, because we had an hour here,
Sure.
what's the best way for us um, to do this to help the vast majority of people? Like, there's got to be a
Um,
way for us to systematically go, because I'm really certain that nobody paid attention in school and or no one's reviewed this again. And I'm willing to spend a couple hours going through this just to get a better understanding. But I
we
think
could do
we have
it.
to actually go through it first, right? Executive summary. This is what this means. Don't you
I
agree?
agree. I agree, and maybe do like a series on it where we just focus on specific parts, like just one on Article One, Article Two, Article Three, Bill of Rights, 14th Amendment, Articles 4 through 7. Obviously, they're important, but those could be like one compact video. Do one individual on the First Amendment, second, third, fourth, fifth through 10th, then go through the structural amendments, go through like the substantive amendments as well. But um, and it all depends. I mean, I could when we're talking about the First Amendment, for example, I could go on for an hour on each of the liberty protected by the First Amendment. Um, the Second Amendment is pretty easy. We could do 1 hour on that. Third Amendment, we could do 30 seconds on that. The government can't force you to quarter troops. Right. But so we could, I think that
Quarter means what? Like
you
separate their
can't be
limbs?
forced to, no, you can't be forced to house them.
Oh, quarter in that term. Yeah.
Yep. So, but yeah, we could absolutely do like a series on it, is what I would recommend because it is a
Well, see, I mean,
lot. I mean,
it's a lot, man. I mean, you studied 12 years of your life to do this, and like people like in the audience going, "Wow, this is hard." And we also need to make sure none of these people are lawyers, right? So we got to communicate in a way that's like, just to me, if we can get them just into the first 2 inches
yes.
and some high level view, because I think there's a lot of misunderstanding on what is and what is not, or what is clear and what is not clear. Why we argue so much and why you end up in the Supreme Court. Which, by the way, I don't know what political flavoring you have, and I'm not going to ask you. Don't really care how you think the Supreme Court's doing, because I think they're doing an awesome job for the most part relative to the shit they've been seeing.
I'd say they're doing quite well. There are cases that they don't take that I badly wish that they would. There's a few legal doctrines that they don't seem like they want to reverse that I so badly want reversed. Like one case, for example, and it's interesting because I mean, a lot of people on my side of the aisle, we are staunch advocates of qualified immunity. I believe in it for like your split second decisions, right? Officers telling someone to freeze, they pull something out of their pocket that's a black object, the officer shoots the guy, it wasn't a gun, it was a cell phone. The officer shouldn't be held liable for that. But when we're talking about a governor deciding to shut down a religious institution for keeping their daycare open when secular daycares are still allowed to come in, I think qualified immunity should be abolished when it comes to those guys. Unfortunately, the Supreme Court just does not have any appetite to revisit that issue. I badly wish that they would. I'd like for our Supreme Court to actually take it further than they're currently going in. But all in all, they're doing great. Chevron is dead, which Chevron is the Supreme Court decision that the entire administrative state rests upon, right? Like the administrative state is on life support because of the Supreme Court. Thank God for that. I'd love for us to revisit our substantive due process analyses, see about whether we should go back to the privileges or immunities clause of the 14th Amendment. There's a whole lot, and Clarence Thomas has been banging on that drum for decades, and I love it every time he does. because man, he's right. We have
TJ,
misinterpreted.
where can people find you? I'm sorry to cut you off because we're at our time limit, but where can people find you on Twitter? I think we're going to have you back on because this has been awesome. I've learned a lot,
Okay.
even if I know it's not exactly super fun, but I really enjoy this type of stuff.
Yeah, I'd
so
love to
where
come
can
back
people
on.
find you on Twitter and look you up and give you a follow?
Yeah, my Twitter is at realtjroberts. If you are interested in following my state representative campaign in Kentucky, my website is votetjr.com. I'm
What
in a
are you
pretty
running for, TJ?
state representative. I'm the Republican nominee for State House District 66 in Kentucky. It's the northern tip of Kentucky, right next to Cincinnati, Ohio. The Creation Museum is actually in my district. So for an idea of where my district is, very good conservative district. It's an honor of a lifetime to be the nominee, and hopefully we can get some pro-liberty legislation through in January whenever I'm sworn in.
There you go. All right, TJ. Well, we appreciate you coming down. Gary, closing notes?
Yeah, no, TJ, thank you very much. It's been very helpful for me. We might have tried to bite too much at one time. That's cool. Love to have you back. Anything that pops up that you would like to convey in the future, reach out to me or Sam. Happy to have you on. Like just hey, this just dropped. There's a lot of stuff dropping. Like for instance, crypto. There was a Treasury tax bill. Like I've talked to 10 of the biggest players in the world in this space. Huh? What you talking about? Like, oh my God. So it's some of these boring things. I think people, when they meet me, they realize how commercial I am, and they're stunned when I spend time talking about lawyers and lobbyists and regulations. I'm like, dude, you can't swing large dollars around in a market unless you know what the rules are.
Absolutely.
And like not to shape and help form the rules is a huge mistake if you're building a business in a space and you're really taking it seriously. So I value people like yourself a ton because it makes my business, like, it's awesome to have a great idea, but it's not so awesome to have a great idea and then lose it all.
Absolutely.
And I can give you a dozen stories where people made a shitload of money and didn't keep a penny. So good to have you. Sam, great idea. Good job connecting this guy. The audience likes him a lot. So thank you very much, sir.
Well, thank you.
Sam, anything else?
No, that's it. Good to end the line.
All right. See you guys. Thank you.